Charles. Apologize. I think I will have to disagree with that assessment in that a grand jury in a criminal process based upon the history of the grand jury going back in the common law to 1200 and something, that is where they are limited to a finding of probable cause, even though the evidence presented to a grand jury can be sufficient to go beyond a reasonable doubt. Their indictment is still simply a statement of probable cause, even if the weight of the evidence is greater. Now, that applies only in the criminal aspect of a grand jury. It does not apply when they are inquiring into the political administration of a government, which is a civil process that is followed by the grand jury. And there they can find facts and they can find law because they have a history of being judges of the law. So I think I would have to disagree with you on that one point, and I'll yield.
Thank you, Paul. I dare suggest that this vote fraud case has involved criminal activity, Paul?
Yes, it does.
Well, then how come you think we're limited to civil process for our remedy here?
We're not limited to civil process. The grand juries wear two hats, and they have worn those two hats from the time of the common law. One is a criminal hat, the other is a civil hat. And in their civil authority, they go look at what's going on in their community that is not criminal, and they judge whether or not the administration of the civil government is being properly managed or not. And if they find that it is not, then they have to establish factual information, which goes to show that that administration is not functioning properly. Now, if they find, and what you get into when you're looking at the question of political administration of a civil government, what you get into is questions of discretion. And in those instances, you have times when a statute enacted by a legislative body will tell, for example, a mayor and council, you shall do this and you shall do it in this manner. And as long as they comply with that, they're okay. But if they don't comply with it, now they can be chastised by a grand jury who finds as a matter of fact that the law says this and you did not do this. That is a finding of fact, and that gives them the authority to chastise that mayor and council for not complying with the law. Now, if, let's take another situation where a legislature says, okay, mayor and council, you can do this, or you can do this, and if you do that, then you do this. Well, let's suppose that the grand jury doesn't do number one, doesn't do number two, but they do number three. There again, they have abused their discretion because the legislature said this and this, and they didn't do one of them. So a grand jury can chastise them, maybe even to the point of removing them or ordering their removal from office. And that happened in the state of Georgia back in 1953 when a grand jury ordered the governor of the state to remove a sheriff from office for grossly abusing his, well, he didn't have discretion. He exercised it, and he didn't have authority to exercise it. So they told the governor, remove him from office. And that's what the governor had to do. The governor was not going to buck a Georgia grand jury down in Liberty County in 1953. So they found, as a matter of law and of fact, that the sheriff was doing things he wasn't authorized to do. And so they exercised their authority to manage the government in the political arena, in other words, the civil management of the local government, and they caused the removal of a sheriff because of it. So that's just a couple of examples that can come to mind immediately, and I yield.
Thank you. Can I ask you why you seem entrenched in the idea that a trial jury can accomplish the exact same thing with even more horsepower?
A trial jury could, but when you go to a trial, you got to understand there's a difference between a grand jury and a trial jury. In a grand jury, you have absolutely no right under most state laws to argue a defense before a grand jury. Now, in a federal grand jury, yes, you do have the right to address a grand jury on the question of probable cause, only the question of probable cause. But in a trial jury setting, you have a clear-cut, clearly defined controversy being played out by two parties, and that takes a lot of time. I mean, I think you said it a while ago, it takes a trial jury about 10 times longer to do what it does than a grand jury doing what it does. And so not only do you have the question of time, but you have the question of expense. And usually to the taxpayer, though in the case of a common law citizen's grand jury, that expense is coming out of those folks' pocket. So, yes, a trial jury could do that, but when you're talking about a common law citizen's grand jury, you do not have a statutorily enforceable subpoena power with that trial jury or with that court that you do have with a statutory, what's called a positive law jury. So, without that subpoena power, a trial jury, without that enforcement of subpoena power, a trial jury really would not be adequate in that situation. It would depend upon the acquiescence of politicians to come in and argue their case, and I don't know of any that would do that, since they would not be in fear of contempt citations or ignoring subpoenas. And I'll yield with that.
Thank you, Paul. I beg to differ with you on your summary that we don't have subpoena power, and that our process will take longer. I don't recall saying that our process with a trial jury would take 10 times longer. I think I said 10% longer. It is a little bit more work, but it's not much more work. It's about 10% more work.
I stand corrected. You did say 10%, and I apologize.
All right. Well, that's not much more work, 10%, in order to get something that the de facto courts can't go in and tinker with, according to the Seventh Amendment. See, that power of the Seventh Amendment says that they have to follow the rules of the common law, which they hate doing. They almost never do. And so that means that if we have a trial jury verdict, it's downhill from there. All we got to do is go in and start barking orders at lawyers and judges and prosecutors and district attorneys, and they're going to be blabbering like idiots because they don't have any words to contradict what our jury's already decided. And I know that's a big pill to swallow. I know you're really enthused about your grand jury process, as are a lot of people. Grand jury just sounds bigger and more powerful and more people-oriented than trial jury. But if you comprehend the history reaching back past 1215 and Magna Carta, back to 1066, another 150 years or so to the Norman Conquest, when the townships and the precincts and the counties were responsibly self-governing communities with their own proper venue jurisdiction,